Welcome to the deep dive. Today, we're going beyond the usual headlines. We're digging into some really complex source material, specifically excerpts from the proprietary LoopCourt documents. These were authored by Devin McClurdy. They're owned by D Investment Enterprise LLC and published by D Publishing Group. Now, these are described as structured vault assets, and essentially they use one specific case to really test the justice system. Our goal here is to unpack what these documents call an acute axiological tension, basically a major clash of values right inside the judiciary. And the case involves a sitting judge, someone previously known for overseeing, well, a truly significant and harrowing national case.
Yeah, it really represents a potential breakdown at the highest level. We're talking about the arrest back in September 2025 of Charleston County Magistrate James B. Gosnell Jr. And you might remember him. He was the judge who presided over that very, very difficult bond hearing for Dylann Roof, the charges against Gosnell, federal possession and distribution of child sexual abuse material, or CSAM. And the McClurdy documents, they don't just see this as one bad actor. They frame it as a potential systemic issue.
The weight of his position, I mean, it's huge. So, okay, let's look at the facts as laid out in these sources. What was the actual evidence prosecutors brought forward initially?
Well, according to the documents, the prosecution's evidence was pretty damning, very direct. Investigators reportedly seized multiple devices, USBs, hard drives, and we're not talking about a few files here. The sources say hundreds of CSAM files, a really large volume.
Hundreds.
Wow. Yeah. And beyond just the files themselves, there were other elements. The sources cite alleged financial trails, payments supposedly made by Gosnell to a known CSAM distributor. And this distributor was apparently based overseas, specifically in the United Kingdom.
Okay, so an international link, too.
Exactly. And maybe the most damaging part, prosecutors pointed to alleged confessions from the magistrate himself. Plus, they apparently had telegram chats. These chats reportedly contained explicit descriptions of fantasies and, disturbingly, planned abuse.
That kind of evidence sounds overwhelming. It seems like it would demand a quick response from the institutions involved. So when we look at how the South Carolina Supreme Court and the federal courts reacted, was their speed appropriate, or, does acting that fast risk undermining due process?
And that's really the heart of the tension these McClurdy documents explore when it comes to judicial discipline. The response was incredibly swift, no question, decisive. Critics might say, and the documents touch on this, that it looks like a knee-jerk reaction, maybe to protect the institution's image. The South Carolina Supreme Court, they issued an immediate suspension, just like that. And the U.S. District Court ordered him detained immediately, no bond. They classified him essentially as a flight risk or a danger, which sort of bypassed some considerations you might normally see for someone in his position.
Right.
Detention without bond for a judge is significant.
Very. And on top of that, federal investigators quickly set up a public tip line. They were trying to identify any potential victims, anyone who might have interacted with him professionally or, personally. So yes, the system was highly reactive. It reacted strongly to the scandal. But the question the McClurdy sources raise is, does this speed prove the system works proactively to prevent this kind of thing, or just that it reacts once the damage is public? That's a sharp point, reactive versus proactive. Okay, so this leads us right into that central legal conflict. You've got the integrity of the judge's office clashing head-on with the constitutional rights everyone's supposed to have. Let's break down those two competing legal viewpoints that the documents analyze.
The clash is immediate. It's stark. On one side, you have what the sources call the prosecution frame. This is built around the idea of a betrayal of public trust. The argument is basically that when a judge commits a crime like this, it's fundamentally different. It's a profound violation of their duty, their fiduciary responsibility, so it requires a stronger, faster response.
More than just a regular citizen's crime.
Exactly. And what's really interesting is how they framed the threat. Prosecutors reportedly called him the ultimate insider threat. It wasn't just about his status. It was about his deep knowledge of the justice system, how investigations run, how evidence works, how the courts are supposed to protect people. This knowledge, the argument goes, made him uniquely dangerous and justified immediate detention. He could potentially use that insider knowledge to obstruct or evade.
Okay, so the prosecution leverages his very position against him. But the defense, they have to lean on fundamental legal principles, right?
Absolutely. The defense frame, as presented in the documents, is anchored in the primacy of due process. Their argument is straightforward. Magistrate Gosnell, despite his title, is entitled to the exact same presumption of innocence as anyone else accused of a crime. His job doesn't legally strip him of those fundamental rights.
So how do they counter the evidence?
Well, the documents suggest a couple of key strategies. First, a rigorous challenge to the evidence itself, especially focusing on the chain of custody for those seized digital devices. In digital forensics, if that chain is broken or questionable, it can sometimes invalidate the evidence. Second, they'd likely scrutinize those alleged confessions very closely. Was there coercion? Was it truly voluntary? Especially given the immense pressure of a federal investigation targeting a judge.
The documents also mentioned a specific tactical move regarding the preliminary hearing. What was the strategy behind waiving it?
Right. Waiving a preliminary hearing can sometimes look like, giving in or admitting something. But the McLarty sources frame it purely as a strategic delay tactic. It gives the defense more time. Critical time to build their case properly, review discovery, and plan their counterattack. It also stops the prosecution from putting testimony on the record too early, sort of locking witnesses into their stories before the defense is fully prepared. It's about controlling the timeline.
Okay, that makes sense tactically. Let's shift gears slightly to the broader implications, the ethical stress test this puts on the whole judiciary. The documents talk about this dilemma, scrutiny versus equality. Should judges be held to a higher standard, judged more harshly? Or does that undermine the principle of equal protection itself?
This is where it gets really tricky, that acute tension we mentioned. If you argue that judges must face tougher scrutiny, maybe faster removal, automatic no-bond orders because of the public trust they hold, well, you risk creating a separate, lesser category of legal rights just for them, which feels fundamentally unequal. But on the other hand, if you treat a judge accused of something like this exactly the same as any other citizen, it can look like you're minimizing the massive breach of faith, the damage to the institution itself.
So where do the McLarty documents seem to lean?
The analysis leans toward the idea that public confidence is paramount. It suggests that if the process for disciplining judges looks slow or too protective, people lose faith not just in that judge, but in the entire system. So from that perspective, the immediate, perhaps harsher scrutiny isn't just about punishment. It's about maintaining the legitimacy of the judiciary in the public eye.
And this crisis of confidence gets even darker when the sources bring up the shadow over past rulings. This is why they specifically mention Gosnell's involvement in the Dylann Roof bond hearing. Remember, he made those comments expressing sympathy for Roof's family, which caused a lot of controversy at the time.
Exactly.
So if a judge, an arbiter of justice, is facing these kinds of charges suggesting, well, profound moral corruption, what does that mean for all their previous decisions? Do we have to go back and re-examine everything, especially cases that turned on judging someone's character or credibility?
It's an almost impossible question. Logistically, trying to review potentially years, even decades of rulings would be a nightmare. It could paralyze the courts. But the argument for integrity presented in the sources is powerful. The challenge posed is, if the public learns a judge harbored this kind of deep, hidden moral deviance, can any of their discretionary rulings truly be trusted? Think about family court, juvenile cases, situations where a judge's assessment of character is absolutely central. Are those rulings now fundamentally tainted?
So what's the conclusion there?
The analysis suggests that the integrity of the process itself demands that decisions come from an impartial, morally sound judge. If that fundamental fitness is compromised by a crime this severe, then certain types of rulings, those high discretion ones, perhaps must be flagged for potential review, even if it causes administrative chaos. It forces a choice between keeping things running smoothly and ensuring fundamental justice wasn't warped by the judge's hidden issues.
And there's that international piece, too, the alleged payments to the UK-based distributor. That adds another layer, doesn't it? What does this cross-border element mean for how U.S. courts handle these crimes?
It immediately throws the limitations of purely domestic law into sharp relief, especially with digital crimes. CSAM distribution is a global network. Supply chains cross borders constantly, and U.S. courts often find it really difficult to get jurisdiction, share evidence effectively, or compel cooperation from other countries.
So the system isn't really built for this kind of global digital crime.
Not adequately, no. The McLarty sources argue this requires a pretty significant legal evolution. Do we need much stronger international treaties? Ones that really standardize how digital evidence is gathered, preserved, and shared across borders? Or, maybe even more radically, do we need new international criminal courts? Courts specifically designed to prosecute these global digital networks that deal in things like CSAM. Because the current approach, relying on existing extradition agreements and cooperation requests, well, the documents suggest it's just too slow and clunky to keep up with the technology facilitating these crimes.
Okay, so if the current system is mostly reactive and maybe not equipped for the global nature of the problem, what about prevention? The McLarty sources seem to push towards proactive systemic changes to stop this from happening again. What kind of structural safeguards are discussed, and why are they considered controversial?
Right, this final part of the analysis really focuses on prevention. But these preventative measures inherently bump up against principles like judicial independence. First, there's a conceptual point. The need to really understand the psychological dimension of authority. It's not just about background checks. It's about recognizing how someone in a position of immense trust, like a judge, can potentially use that trust, that authority, as a shield. It allows wrongdoing to hide in plain sight because people are reluctant to question the integrity of someone in that role.
And the specific proposals, I imagine they'd face serious pushback.
Oh, absolutely. They are controversial. The first one mentioned is mandatory digital audits, but specifically on court-issued computers and equipment. The argument is deterrence. If judges know their work devices could be audited, it might prevent misuse, and it could help detect issues early. The massive counter-argument, of course, is judicial independence and privacy. Should judges have their work communications subject to potential state surveillance? It raises serious separation of powers concerns.
Definitely. What else?
Second, the sources discuss enhanced psychological screening for judges, maybe even periodic assessments throughout their tenure. The goal is clear: identify potential risks, ensure fitness for office. But again, huge tensions. Who designs these screenings? Who interprets the results? Is there a risk of political bias influencing evaluations? It pits institutional safety against individual privacy rights.
And the last one involves bringing in outsiders.
Yes, the idea of creating independent accountability boards. These boards would include people from outside the judiciary, ethicists, maybe lay members of the public. The aim is to have truly external oversight, taking discipline out of the hands of judges, potentially evaluating their own colleagues, which critics argue can lead to self-protection. But giving an external, potentially non-judicial board the power to discipline judges, that's probably the most direct challenge to the separation of powers discussed in these documents.
So wrapping this up, our deep dive into these McLarty LoopCourt documents really lays bare this fundamental conflict. The Gosnell case becomes a sort of crucible, forcing a confrontation between two critical needs. One is that absolute sacred right to due process that everyone gets, no matter who they are or what they're accused of. And the other is the non-negotiable need for institutional integrity. Without public trust in the courts, the whole system falters.
Exactly. The sources really push us to think hard about where that line falls. If we accept that this kind of profound moral failure by someone in a position of judicial power truly contaminates the process, what are we prepared to do about it? It leaves us, and you listening, with that really difficult question that seems to be echoing through the legal community right now, based on this analysis. If an arbiter of justice is found guilty of crimes against children, crimes of such deep moral turpitude, is the system itself obligated to go back, review, and potentially discredit their entire judicial record?